Yeah. Oh, yes. Whenever you're ready, we're all ears.
Good afternoon. I'm Elizabeth Russell. I'm appearing on behalf of the appellant Mazie White in this matter. This is an appeal from a juvenile court in Williamson County concerning parentage and child support.
Do you want to save any time for rebuttal?
Yes, sir. Thank you. If I could, probably 5 minutes for rebuttal, please.
5 minutes, okay.
Mother's primary issues on appeal regard the trial court's findings regarding father's income, as well as the trial court's decision to deny retroactive child support in full back to the date of the child's birth, as well as declining to award mother her attorney's fees in this matter. In February of 2018, Mazie White found out that she was unexpectedly expecting. She had just turned 20 years old. She was a student at the University of Tennessee, Chattanooga, and she was not sure what she wanted to do with her life, much less what she would do with the life of a child that she was now carrying. Ms. White made considered decisions. She thought about all of her options, and she decided that not only did this child deserve a chance to be a child, but that she was also capable of being a mother and deserved a chance to be a mother as well. She made decisions regarding her education at that time, which was to put her education off in order to take the pregnancy to term and to be a new mom. And she obtained a job, a full-time position at Vanderbilt Children's Hospital that would, while the pay was not at the time exactly what she needed, it was a step in the right direction in terms of providing the benefits that she would need for her child. She did not delay in informing the child's father about the pregnancy. In fact, it was one of the first things that she did after she found out. The father, and this is covered in the brief, I'm not going to go into it in great detail here. Father was not as keen about having a child. He'd offered her money to not have the child. He asked her how much money it would take for her to go away. There were times when he flatly denied any type of involvement or any type of contribution or even any type of awareness of the child. He finally did come around, although initially the father's request was that his family could never know about the child. Eventually, father did come around, and thankfully, father is involved in the child's life. Both parents are involved in the child's life, and I think father now realizes that he made the correct decision. However, for mother, it was a long road getting there. After she informed the father, she carried on with the pregnancy, and she gave birth towards the end of the year. Father did attend several of the appointments with mother. He took a tour of the hospital with mother. He wasn't present when the child was born, but he did begin seeing the child somewhat right after the child's birth. He was not financially contributing at this time to the child. In fact, mother requested that he financially contribute, and he sent her several Venmo payments, one for $20, I believe, for formula, another for $17. It was not until Ms. White decided to contact the state of Tennessee to determine what to do about the child that she had, who had been on TennCare, and how she was supposed to support this child when father was not willing to engage in the child's care at that time. On behalf of Ms. White, the state of Tennessee assisted Ms. White in initially filing an action in the Davidson County Juvenile Court. After a period of time, Ms. White heard directly from Mr. Miller, and I'm sorry, father's is Thomas Miller. Ms. White began receiving correspondence directly from Mr. Miller's attorney and determined that it was appropriate probably for her to have representation. The parties agreed because mother was living.
If I could maybe jump to a little different piece of this here in terms of part of your argument is that the trial court didn't appropriately consider the promissory note,
Yes, sir.
Didn't appropriately consider capital gains that the father had. in reviewing the order, it looks like the trial court did give consideration, or gave consideration to the promissory note. How is there error in that consideration? I'm struggling to sort of follow that, because I have a court that looks out and imputes a certain amount here based on how the father is living, but isn't that in consideration of in part at least, of the promissory note and the capital gains in this case?
Yes, sir. First, thank you. The time goes by quickly, so I appreciate you directing me directly to the issues the court's concerned with. Mother's argument is that that promissory note doesn't meet necessarily the terms of a promissory note. What it really is a gift. It's father's parents gifting him money, and it should have been considered in what his imputed income was.
How does it, let's say we do look at it, let's say the trial court. I'm not sure the trial court didn't look at it that way in terms of how the father is living. The trial court's essentially saying he's living as if he had $60,000 a year coming in.
Yes, sir.
Isn't that treating the promissory note as a gift rather than or as a pure loan in terms of how the court's already looking at it?
Possibly. Mother's argument is that the terms of the note are open-ended, and considering father's attorney's fees and his ongoing support obligation at $1,423 a month, that promissory note was a gift, and it was in actuality an extraordinary amount of income for father, and that $60,000 that was imputed to father really covers everyday living expenses: rent, his vehicle, his cell phone, his vehicle insurance, food, whatever father was doing during the day at the time. The $60,000 imputation of income, mother contends, was simply not enough, and was an abuse of the trial court's discretion to acknowledge that the basis, or the promissory note itself, was a gift, and as father admitted, the promissory note was entered into during the course of the litigation, and that it references certain financial accounts that mother was not aware of or provided information regarding.
Let's talk about one of the accounts here. So part of the argument in this case relates to capital gains, and we have a changing, I believe it's the Wells Fargo account here, where there's an increase in valuation. The trial court references looked at that, essentially made a determination that I think this amount constitutes capital gains that should be considered. Is your argument that the trial court should have also factored in unrealized capital gains as part of its consideration? Because I mean, part of it the argument seems to be related to what was actually dividends and what was accounts changing through valuation otherwise.
Yes, sir. I think the crux of what mother is getting at is that this is money that is available to father. And yes, the unrealized gains should have also been considered, but the basis itself for those investment accounts was in father's name and was in fact gifted to him from his parents. So not just the unrealized gains, but the entire amount itself is available for father. And I believe the child support guidelines, it's consistent with the child support guidelines in that it affords the trial court the opportunity to look at all aspects of what a parent has, not just the net capital gains off of the investments, but the actual basis itself, and looking at what a parent has, because ultimately it's about the child and supporting the child.
Counsel, would you agree that the trial court, in laying out the decision in this case, did though say, I'm considering the capital gains, I'm considering this money, I'm considering the gifts from the parents in this case, and all of that, it's laid out as part of the court's oral discussion, at least, of this matter, isn't it?
Yes, sir. Though the court laid out those things, mother contends that it was abuse of the court's discretion to set his income at $60,000, that there was ample proof in the record, though it, by father's own testimony, how reliable father's testimony and the documents he produced was a different question. But mother contends that it was an abuse of discretion not to set his income higher, and that he should have considered all of the the monies that father had available, particularly in light of the fact that this child was being funded by TennCare at the time, when father had extraordinary means and an ability to pay for this child and an ability to ensure that this child was taken care of right from the very beginning. So, and to go directly to the final two issues is that mother believes that she is the prevailing party in terms of this action, which would entitle her to an award of attorney's fees. Mother sought out father. He always knew that he was the father of this child. It was never in doubt. She pursued filing the petition. She pursued contacting the state of Tennessee in order to find out how to file the petition. She was a prevailing party in that she prevailed in securing support for her child. So I will save the last 5 minutes that I have. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, Sarah Richter-Perkey for the appellee Thomas Gray Miller. So I believe that this is a pretty straightforward case. I did not try this case. I'm just involved in the appeal. The first issue is whether the court correctly imputed income, basically to father. No one is contesting that the court improperly imputed income. They're just really contesting the amount that was imputed, right? And so in this case, Mr. Miller was not able to meet his own basic living expenses. The proof was undisputed. This was a gentleman similar to Mom who had just graduated college. He was buying his gas on Costco gas cards. He was living with 3 other gentlemen in a house in Nashville. But when he found out that he was going to be a father, he wanted to support this child. The proof is uncontroverted that he entered into a secured written promissory note with his parents, by which they advanced him $1,400 per month so that he could pay an agreed amount of child support. And he did that by agreement, before they went to court, right? He did that by agreement, and he did that for over a year by agreement before this matter was actually heard. For our first position, Your Honors, is that this promissory note was a loan, and so it should not be included in his income for the purposes of calculating child support. The guidelines are pretty clear about that. Mother makes an argument in her brief that the note failed to comply with the UCC. I think that this is what we might refer to in law school as a red herring. The UCC only applies to negotiable instruments or commercial contracts for the sale of goods, so it doesn't apply here. Really, we're talking about basic contract law. There was no dispute. Mother does not advance an argument in her brief that this was not a valid contract. And there's no real proof of that in the record either.
Is there any proof of him repaying the loan yet?
No, Your Honor, but there's a term. So the term said that it was due and payable in August of 2025.
Okay.
And it attached an interest rate to it, and it is actually secured with this investment account that Mom says, well, let's use that to set child support. Let's use this investment account to set child support. So I think it is a valid contract. It's got all the right terms in there. However, even if the court finds it not to be a valid contract and that these monies were advanced to father as gifts, I think Your Honor was exactly right that the trial court considered that. The language from that the court talks about is it says that it considered gifts from father's parents, and it also considered gifts which would have reduced father's living expenses. So I do think that the court incorporated, considered, and weighed those facts in imputing $60,000 to father as his income.
And so I wonder if we could talk a little bit about the retroactive support issue.
Yes.
I'm struggling a bit with that one in terms of how the court was looking at it. And we have a court that essentially says imputing $60,000 and being pretty clear that $60,000 is the whole time period here. And yet, in looking at retroactive support, the trial court seems to have looked at the lesser amounts before it went to $1,400, as in $1,423, I believe, is the final award amount.
Right.
That those lesser amounts as essentially meeting the support obligation. And maybe I'm misunderstanding the math here, but it looks like we have the month time period where there was no payment or nominal payment, $17 here, $19 there, where you've got the full $1,423 coming into play. And then once we hit the $300 payments, it disappears. Or am I misunderstanding the retroactive support payment? And how
I
it's
think that
structured?
you're pretty close. So I tried to go back. I was obviously not a part of the trial, but I read the record just like you did, and I tried to go back and do the math, basically. My understanding was the retroactive award was based on from the birth of the child from October of 2019 through February of 2020. And during that period of time, the court kind of said Dad was only paying nominal support. He really wasn't doing his share. And then the court, and so for that period of time, the court gave Mother $7,115. And then the court said, beginning in March of 2020, Father voluntarily started paying this $1,400 per month, which is only $2,300 less.
And that $1,400 a month was an agreed amount?
It was.
Okay.
And it's in the record. The parties went to mediation. They agreed. And so he continued to pay this $1,400 up until the time of
Wasn't there a
trial.
time period of $300 payments before we got to $1,400?
I think that that's part of that nominal support. So I think that the court, this is my understanding, that the court calculated October of 19 through February of 2020 was the period of time. And then in March of 2020 is when Dad starts paying $1,400 per month by agreement of the parties. That's how I recall the facts being. And so basically my understanding is what Mom is looking for is an additional $3,914. And that's from March of 2020 until the entry of the final order. And the case law is pretty clear. Mom says that the retroactive award of child support is mandatory. Now, I've cited lots of cases in my brief. It is not mandatory. It is clearly discretionary. And the court is supposed to consider the equities between the parties, right, in making this decision. And I believe that the court did that here. I don't think that we can disregard Mom's position. When Mom comes into this litigation, she says Dad should have 54 days per year with his son, and child support should be set at the statutory maximum of $2,100 per month. This is also a gentleman that wasn't ready to be a father at that point. He didn't have the financial ability to do it. There's no reason that it should have been set that high, and there's no reason his days should have been limited to 54. Now, conversely, Dad says, hey, here's a parenting plan. This is what I'd really like to have. That parenting plan, Your Honors, was almost adopted in full by the trial court after 2 years of litigation. They try the case, and the judge basically adopts Dad's parenting plan. In the same vein, this child support amount of $1,400 per month that the parties agreed upon, a couple months after the child was born, the court ends up ordering a final child support award of only $23 more per month. So I think that we can't forget that the court is seeing this and saying, how did we really end up here? This could have been resolved probably 2 years ago and avoided all of this back and forth and all these attorney's fees that really neither of these parties could afford. So I think that the court properly exercised its discretion, weighing the equities between the parties. I believe that there's also some testimony about how Dad paid for both of the mediations. The parties went to mediation twice, that he paid the full freight for both of those in an effort to try to get this resolved. So I think that the court was also considering that. Yes, Your Honor.
So I want to go back to the retroactive support, just because there's a reference I'm finding here that seems to suggest that in March, April, May, June, and July of 2019 that the payment was $600 a month, and that it wasn't until after July, in August of 2019, that the $1,400 payment started. So it seems like we have a time period running from March through July where it was only $600, with the court not awarding the amount at the $1,423 during that March to July time period. And I don't think there's any, at least I didn't see any explanation from, maybe I missed it, from the court in terms of why a different amount of retroactive child support was being provided for from March to July. than from, October through February. And maybe I'm missing something, but it looks like there's a time period of 5 months that was at $600 rather than $1,400, without any real explanation as to why that amount was adequate for that time period.
So I'm reading the brief, my brief again, and what I have is that Mr. Miller voluntarily paid child support of $37 from October of 18 through December of 18, and then $300 biweekly from March of 19 through July of 19. And that was also by agreement of the parties. And then $1,400 per month by agreement of the parties from August of 19 until the court order setting child support at $1,423. So I think that I think that the math is that the court gave mom a judgment for this $7,115, which represented, I think it would have been through February of 2020, but I'm not sure if that math is right.
February 2019 or February 2020?
I've got February 2020, but maybe my math is wrong.
All right. I may be lost on my months here, but
I'm sorry.
is there?
It wasn't. I would agree that it's not super clear exactly how the court came to the exact figure that it came to. I would agree with that.
If the amount, let's say the record does reflect that the amount is less than the $1,423 that the court viewed as being appropriate. Is there, if we've got a deviation in amount, then under the guidelines, the court needs to provide an explanation of why they're deviating on the amount. And you would agree with me, there's not an explanation of the deviation. So if we do have a deviation there, that it's an unexplained deviation.
Well, I would say that it is, it wasn't explained the way that we would typically see it, right? So a lot of times we like to see, here is the amount that it should have been, here's the amount that the court's ordering, this is the deviation, and this is why. So I don't think it's reflected that way. But I would say that the court does talk about the litigation, the type of litigation it had gone on, that they had gone to mediation a couple times. I think that the court does say that.
Doesn't the trial court have to, though, provide a written finding, according to the guidelines, that the application of the guidelines would be unjust or inappropriate in the particular case and tribunal, and the best interest of the child or children who are subject to support and award determination are served by deviation from the presumptive guideline amount? And that seems like it's lacking to me in terms of that 1423 to 600. Maybe there's a great reason for it, sure, but I'm not sure that I see it
right
in terms of what I'm looking at. And we may have confusion on months, and I may be missing something.
And I get exactly what the court is saying. And I don't think that the order reflects the language that is in the child support guidelines that they want to be in there. But I do think that in reading the decision from the court, that it does explain how the court ended up where it ended. And I do think that it adheres to a balancing of equities, and I don't think that it was an abuse of discretion. So I do want, if the court doesn't mind, I do want to address attorney's fees. So in this case, mom is contending that the trial court abused its discretion in denying her award of attorney's fees. Now, the only way someone gets attorney's fees is by contract or by statute, right? Our jurisprudence is set up that everybody pays their own fees absent those circumstances. Now, mom is relying on TCA 365103. In order, the condition precedent is you have to be the prevailing party, right? You have to be the prevailing party to get attorney's fees under the statute. Now, what is a prevailing party? It's defined under Tennessee case law. A prevailing party, a litigant must prevail on a significant issue in the litigation. Now here, the trial court adopted father's plan. So I think that dad prevailed on that issue. Mom asked the trial court to set child support at $2,100 per month, the statutory maximum. Dad asked the court to set child support at $1,400 per month. I think that mom also did not prevail on that issue. Although dad did not technically prevail to the tune of $2,300 a month, I think that it was much more aligned with what he was proposing to the court compared to what mom was asking the court for. I think that there is no argument in mother's brief that she was the prevailing party. It's a very difficult position to assert in this case, based on the facts. And I also think that it's important to consider the litigiousness that was involved in this case. I think that there's a lot of attorney's fees that were incurred unnecessarily. This should have been, in my mind, a very straightforward matter, very easily resolved, and this went on for 2 years. Finally, my client is asking for his attorney's fees on appeal. That is the only issue that he has raised. We've discussed mom's issues. I don't believe they have a lot of legal merit on appeal. And my client also, like I said before, had just finished up college. When he found he was going to be a father, he didn't have the ability to go through 2 years of litigation about this child. He offered to pay $1,400 per month in support, and he said, I just basically want 80 days with the child. He does not have the financial means to pay for this litigation, and so we will request that if the court does affirm the decision of the trial court and find that his position or the position of the trial court is correct in this case, and the court did not abuse its discretion, that the court consider awarding him some of his attorney's fees on appeal. Thank you, Your Honors.
Thank you. Ms. Russell, you have 5 minutes.
Yes, sir. I can offer some insight into the $1,400 child support amount. That amount, while agreed to in theory, not in spirit. Parties attended mediation. Father had produced no income information whatsoever. Mediation had to be reset for a second day. When we attended mediation the first day, obviously mother was concerned about continuing to provide for this child without any support. And the parties came to a mediation agreement not based on any financial information provided by father for him to pay $1,400 a month. That was a confidential mediation agreement that mother agreed to be confidential, and it was written in that it was confidential and would not be filed with the court. Father, nonetheless, filed this mediation agreement with the court and relied on it as though mother had agreed to this amount based on some actual financial standing that father had. That was not the case.
The agreement says that it's confidential and not intended to...
Yes, sir.
To be, okay, and that's in the record?
Yes, sir.
Okay, thank you.
Counsel, can you offer some clarity on the retroactive child support issue? Is there a 5-month window here where the amount was $600 rather than $1,400?
Yes, sir. There was no agreement for father to pay $600. When he hired an attorney, he began paying $300 biweekly until the parties attended mediation in August of 2012 and reached this confidential mediation agreement that he would pay pendente lite until he could produce reliable income information. So
the retroactive child support award here is October, November, December 2018, January, February of 2019 at the $1,423 amount, but there's not a retroactive child support amount that covers March through July of 2019. Is that correct?
Correct. Okay. Or any of the mother's medical bills or anything associated with pregnancy. I think it's also important to note that the litigiousness was based entirely on father's inability to produce any type of income. Father, yes, he had a college degree. He was willfully, it's generous to call it underemployed. He was unemployed, and by choice. He had a degree from a prestigious private school and was choosing not to use it. And when asked directly, why don't you get a job at Home Depot? Why don't you get a job at Chick-fil-A? Just something so that this child is not only not on TennCare at the taxpayer's expense, but that you have some type of income coming in. He just determined that that wasn't within the realm of what he wanted to do on a daily basis, and that he was looking for bigger things, looking at the bigger picture. This baby is the entire picture from mother, and she had no choice but to make this baby the entire picture. Father had the luxury and the privilege to address this baby when he wanted to, in the manner that he wanted to. The parenting time was agreed upon by the parties. It was not ordered by the court.
And counsel, in setting the amount, though, that's imputed here, and the trial court did consider how father was living, right? And there's a lot of money father has a lot of money coming in from his parents in terms of providing for his well-being. And isn't the trial court considering all of that and setting the amount, saying that I think that this person's life and how he's living and all the money that's coming in, he's got about $60,000 a year worth. And when I look at his degree, when I look at what he can do, I think that's the appropriate amount. And hasn't the trial court, this is sort of separate from the retroactive child support issue, but with regard to the promissory note and the capital gains question, isn't all of that really in the mix in terms of what the trial court's thinking about here?
I don't believe so, and this is why. The trial court's order was primarily based off of father's inconsistent testimony about cash that he had in a shoebox in his closet, about cash that he was depositing into an account and withdrawing at an ATM at the Belmead Country Club. Father did not produce hardly any reliable documentation that was admissible in an admissible format. He could not even identify his own tax returns, which were in fact not the return, it was a draft. So I think the trial court did the best it could with the testimony offered by father, but it is generous to call father underemployed. Father is living well in the nations. He has an extraordinary amount of time to go out and to spend money on the things that he wanted to spend money on. Drinking, dating, and other things, which is all expected of a young man or young woman at that age, except for when you have a baby.
Thank you very much.
Thank you.
Thank you as well. I think that concludes the docket today, so could you recess court?